And now there's got to be super wisdom in the crowd, because we must influence individually and collectively the government and the judiciary of this country to re-establish the Charter of Rights and Freedoms that we intended it to be in 1982.
Courts, both the federal court and the Federal Court of Appeals, say they didn't even meet the Act, let alone the Charter.
Don't forget that the Constitution is not a federal law. The Constitution is not a provincial law. The Constitution is not a little puny municipal bylaw. The Constitution is the supreme law of Canada.
They went out of their way to make the point, look, this is Section 8 here, and what you've done. And then, of course, to go on to explain that there's no means by which anybody could find out, why are you doing this? What are your reasons? What are your grounds? How can I appeal this or anything? The person, the citizen, was left naked.
Well, hello, everyone, and welcome to Freedom Feature. And I'm your host, Barry Bussey. With me today, I have the Right Honorable Brian Peckford, the former Premier of Newfoundland, who's joining me. And we're wanting to talk about the Federal Court of Appeals decision with respect to the Emergencies Act. Mr. Peckford, it's great to have you with us again.
Great to be here.
So, you have been, as I have pointed out in a piece recently, that you were prescient in the sense that you were calling upon, I remember very clearly, February 13, 2022, standing in front of the stage, and you were giving this speech about the importance of civil disobedience, but doing it in a very peaceful way. And you also said that it's important for the people in Canada to influence the courts and politicians to ensure that our rights are protected. Now, that was a great speech, and it's one that I'm going to be, I've already put a little piece of it up on my Twitter account. But tell me, as you've read and understand what's been going on with this federal court decision that was released about a week ago, what do you think?
Well, I think my idea during that speech, where I was trying to ensure that, democracy is only as good as the individuals in it are being active and advancing the cause of freedom and liberty and democracy and all the things that we stand for and that many fought for. And so I think it's come sort of full circle in that with this decision, my post was to say, I hear very little people either celebrating it or saying that this is wonderful. We've got to, that means, that we can have an impact, that we should get on with ensuring that other parts of what happened during that time are seriously considered, and that we stand up for what it is the court has supported us in doing. And so, whilst I have a great deal of pleasure in noting that the Charter, which I was very much a part of, and these parts of it in Section 2 and Section 8 and so on are being celebrated now and being made to work and to show that the federal government was wrong, I'm rather concerned at the reaction to such a wonderful victory and how muted it is across the land. And this is not good news in that sense, because, like I said, democracy is only as good as how active the citizens are in participating in that democracy.
Yeah. I found the decision to be filled with great, let's say, pithy statements, where the idea of the governor and council, which of course is the legal term for the cabinet, that they are subject to the law. Like, in other words, they can't be just simply making up the law as they're going along or interpreting it. They've got to be reviewed by the court, and the court is reestablishing a very powerful connection that the people must rely on the judiciary as kind of like the stopback against government overreach. And so I thought that was just absolutely fantastic how the court did that.
Yes, I've been reading the decision again yesterday and again this morning before I came on the show with you. For that very reason, I'm so glad you raised that point, because, you know, in reading that decision, in the early part of the decision where the Federal Court of Appeal reviews the federal court's decision, Justice Mosley's decision, they go through it in great length before they then do their own thing as to whether they agree with the federal court or not. But in doing that original early commentary, you are so right in how they describe and go through that whole thing, to the point of where I was really surprised that the federal government, for example, would try to use this so-called distinction between the governor and council and the cabinet.
Yeah.
They're unbelievable, some of the arguments that the federal government used. I mean, the Federal Court of Appeal really had no choice but to embarrass them, reestablish what it is to have words mean something, and words in an act mean something, and words in a charter, you know, and the general functioning through words of our system. And I was so happy to see that they took the time to go through all of that early stuff and mow it down quite easily in their arguments and in their references. I thought that was absolutely wonderful. And then to go on and make their own points to verify what the federal court had said was quite wonderful. And you know, Barry, I had to wonder if those three people were overseeing my case on the travel ban, and how the court used the mootness argument to not allow 6 million people to know whether their rights were violated or not. I don't know if we would have got the same decision or not, because I thought, and I still, you know, I wake up in the nighttime and in the mornings thinking about how the courts use that. And of course, it went through the Federal Court of Appeal and the Supreme Court of Canada too. But I only think as if some of these judges had their time back, whether they would do that, given the way and the tone and tenor in as you say, establishing that everybody is subject to the law, and that the charter means something. The other thing is that the court actually had to mention, I think it was around 150 or whatever point of the decision, where they talked about having to remind the government that the charter was in the introductory to the act, saying this act, Emergencies Act, is subject to the charter, right in the introduction to the Emergencies Act itself.
Yep.
And so, it is a wonderful, pithy and easy to read. You know, I encourage anybody who's listening to us right now or watching us right now to take the time to go in. It's quite accessible. Just plug in Federal Court of Appeal, click decisions, click 2026, and there it is.
Yeah, there it is. And you know, I think it's a very important. I mean, obviously, this is going to be talked about a lot in the law schools across the country. But you know, one of the things I have observed over the last number of years, is the fact that there is this attitude within the legal community, and I think, and obviously in a lot of judges throughout the country, who often are not wanting to deal with the law as it is, but to make decisions on what they feel the law ought to be.
To be.
And this decision says no. That is not how we do law in Canada, or we should be doing law in Canada. And I think of Justice Laskin, if I'm not mistaken, who is part of this decision. He
Yes.
also is an author of a set of constitutional law books that I have here on my shelf. That when I was going through law school, we used his textbook, and so he is like, to me, is when I saw him on the panel, when I saw the decision, I was like, yes. I mean, here's a guy who's got the intellectual interest, capacity, and vigor and I should say he has the an amazing reputation in the legal community to be able to make such a powerful statement. And the other thing is when he says, when the court says, that it's, that yes, look, the government is subject to the law and it doesn't have the authority to just go ahead and come up with its own definitions. It has to be in accordance with the courts, and so and subject to judicial review. And as I'm listening to this, I'm thinking of what's going on in the law schools across the country, where you got this attitude that we need to change the law. So like everyone goes into law school with the idea of we've got to kind of like make the law in our own image, and
Right.
without realizing, like as in with the Emergencies Act didn't just come out of nowhere. It came out of the experience that we had in the
The
1970s.
War Measures Act and
Yes, right. The War Measures Act and all the rest. And it said, and you could tell the way that act is crafted, that there was a lot of energy put into ensuring that there was check and balance on the government.
yeah, yeah. And it was interesting that they would see fit to quote Perrin Beatty, who was the minister who introduced the Emergencies Act, amending the old War Measures Act, and to
Right.
quote it along the lines that we were making the definitions of what really this was all about more certain than it was under the War Measures Act.
Right.
I thought that was very, very telling because the judges, as you say, they go to law school now thinking that they're going to come out and help change it rather than look at what is and what the elected people decided the Constitution and the Act is. It was
Right.
the Parliament of Canada who passed the Emergencies Act, not a court of the country.
Hmm. Yeah, exactly. And so so anyhow, okay, so now a lot of people will ask, okay, and your blog post recently just kind of says, okay, what now? Like in the sense of how are we going to bring people accountable? And this is something I think it's extremely important. How do the people who've made this decision and who, in my opinion, um, um, looked at the act and says, hey, you know what? This is just an impediment for us to get to the political goal that we're after, and which is bringing out the Emergencies Act because we want to enforce our will, and kind of like running roughshod over the law and over the Constitution. I mean, how do we bring accountability here?
Well, I think that's the next step, which is very, worrisome to me, because Barry, many of the people that I was involved with or who contacted me and through whom I expressed my opinions and so on, and quite a lot of people across the country, both in formal organizations and otherwise, have gone silent.
Yeah.
And, believe it or not, of all the people I sent this out to, the lawyers, I haven't heard from anyone.
Oh, wow. Yeah. Wow.
So I don't understand that. I just don't understand that at all. It's amazing. When we got wind, when I was in Ottawa that day, and when we got wind that the federal government, the cabinet was likely to make this decision to invoke the Emergencies Act, we took it upon ourselves at the time just to start, reading right away the Emergencies Act itself, in which it said, it had to be subject to the charter, and all the other things, and then going on from that, for the next couple of years, the excitement to bring some justice to the system and to bring some meaning to this charter, and to, by the way, what was actually written and talked about, as the courts, both the federal court and the Federal Court of Appeals, say they didn't even meet the act, let alone the charter.
Yeah, I know.
They didn't even meet the conditions of the act.
Yeah.
And that's quoted extensively throughout that decision, both in reviewing the federal court's position, and then the Federal Court of Appeal doing its own position. That they didn't even meet the conditions of the act itself, let alone the sections of the charter, Section 2 and Section 8. And really interesting to note that they went out of their way to make the point about seizure. The Section 8 dealing with the seizure.
Yes, with the freezing of bank accounts and so on.
Yes, and that freezing the bank accounts essentially was seizure.
Yeah.
And they had to make that point. It's silly to think, that you have to make those points to other lawyers and other people who are well versed in the legislation. But they went out of their way to make the point. Look, this is Section 8 here, and what you've done, and then of course to go on to explain that there's no means by which anybody could find out, why are you doing this? What are your reasons? What are your grounds? How can I appeal this or anything? The person, the citizen, was left naked.
Yeah, absolutely, absolutely. And we've heard lots of stories of individuals going to the grocery store with their full shopping cart full of groceries, and yet they're unable to even access their bank accounts. I mean, what was done here to individuals was absolutely extraordinary. It was an abuse, and now we know it was unlawful. Okay, so what now? Like, I mean, how do we hold them? How do we hold them accountable? How do we, I can't help but think, and I've mentioned this in some of my writings and in my book and so forth, about how it is that you get a leader, right? The prime minister, he voices what his opinion is, and then everyone around him does everything they can to ensure that what he wants is carried out. Now, it would appear, based on what the court is saying and how it's approached this, like it was not only unreasonable, but was it not a sense of, we don't care what the law is.
Yes.
This is the political motive. This is the political goal, and that's what we're after.
Barry, and apropos that point, the Federal Court of Appeal, in the last section of the decision, talks about this in the sense that when the cabinet was deciding on whether to invoke the Emergencies Act or not, they had access to that that information that became public later in the court. The court agreed that this should become public, about the briefing from CSIS, in which they said they could not find under their act where there was sufficient cause to call this an emergency, or to say that it can't be handled under existing circumstances and existing laws and existing people and organizations and the government. And I mean, that was so telling. And they go on to explain that, what the CSIS was saying there, was really important and had to be given a lot of weight in that final decision, whether to invoke or not to invoke. And then the court didn't stop there. This is the other good thing about it, and I guess Alaskan had a lot to do with this. I'm not familiar with the other two judges, although one I see was the chief judge, and the other person who was a lady. But obviously they all sort of agreed on this. But they went on to show that the cabinet never even took the moment to say, well, let's further question the CSIS on this.
Yeah.
Let's further question them on that. Let's get a little bit more on this, why they're saying this, to see just how strong they are on this? Or can we get some other people to give us another opinion, either some people in the RCMP or some other people to give us to challenge what the CSIS is saying? They didn't do any of that.
Right.
They had no other opinion, only that one, which they ignored.
Right. Right. Yeah, and so I guess I'm very curious, and I've said this many times. There was a reference in the Rouleau Commission, in which, by the way, I fully agree with you. I mean, in your blog, you point out that was was it the term sham you used?
Yeah.
But like, I mean, indeed, I mean, here it is. The government is inspecting itself or reviewing itself.
Yes.
Wasn't independent. It all of that. But anyhow, during the Rouleau thing was the idea of this brief that was given to the government from the government lawyers to the prime minister.
Yeah.
And they never made that public because they said it's solicitor-client privilege. Well, I say that when we're dealing with a situation that involves such overreach of government power, that brief is, as we are now looking back over it and sizing it up, we, the public, every citizen needs
the right to know,
has the right to know, has the right to read it, has the right to understand. How is it that the legal opinion would lead them to make
which is crucial to this exactly. Yeah, no. It's the other thing, I mean, none of the political parties have proposed some changes to the Emergencies Act to ensure that when and if they had to invoke this again, that there's an independent inquiry, not one that has established by the government to examine themselves. They haven't even done that.
Yeah.
They haven't even done that. I mean, we're the opposition party. We're talking about bringing this decision, which is so good from our point of view in the sense of establishing the charter and establishing the rights of individuals. And, there has to be unbelievable, sufficient, real evidence before you can start going ahead and doing things and stuff. And that's well defined out. Well, then why hasn't the leader of the opposition, who wants to be prime minister, and the Conservative Party of Canada, why haven't they put a proposal before the House of Commons of amendments to the Emergencies Act to make it more democratic, if in fact it has to be used again?
No, absolutely. And again, it's part of the accountability that's required now.
Exactly.
Yeah,
exactly. And then of course there should be also a House of Commons. I believe the changes that have to be made to our system involved having the elected more involved. And therefore, my proposal would be that the opposition parties, if in fact the government is not prepared under a new prime minister to see the error of their ways and start making changes for accountability, that at least the opposition parties should come together and make a pretty big proposal about involving the House of Commons in an inquiry of a couple of years, whereby they go through all of this stuff and determine where the accountability and transparency was lacking and what should be done about it.
I think this conversation is extremely important right now, given the context of the increased tension that's going on right now between Canada and the United States. And now, the Prime Minister is making decisions and trade agreements with China and all the rest. We don't know what's down the road for a government to say, oh, you know what, we're going to bring in the Emergencies Act now because of whatever tension or reason that would come about. And it strikes me that now is the time for us to have a look at what we just experienced to say, hey, coming up to the future, as you point out, that we need to get serious about that, and we need to make some noise about it in the press and all the rest. And I know you're doing your best.
Well, my problem is that the press won't carry anything or write anything more.
Yeah.
Nowhere. I'm not allowed. So that'll give you an idea how far this has gone the other way.
Yeah.
The
Yeah.
most reasonable stuff that I write is just ignored.
Yeah. Yeah.
And
Yeah.
so I'm persona non grata because most people know I'm completely, utterly independent of everybody, and therefore I can speak my mind, and that I have a good memory.
Mm-hmm. Right.
And listen, what you just said is so apropos, because it didn't take very much. Only a very ego-oriented guy who likes to hear himself speak and who likes to say things which he can't sort of back up. Donald Trump, many times, even though he's done some good things, he's also got involved. Here we had Denmark and the European Union sending troops to Greenland because they thought a pending attack by the Americans was likely.
Yeah.
Because what one person said, of course, he had to haul in his horns, and very quickly now, when he got over to Davos and stuff. But nevertheless, to see how quickly
Things can change.
Things can change, and that the powers get carried away in a bubble of their own making, largely, and exaggerate what is already an exaggeration to the point where it gets really nasty. And so that's what happened during the Emergencies Act. That's what happened for it to be invoked, and we can see how quickly it can happen. How people wouldn't even talk to me because they could get the disease, and so on. So
Yeah.
you're so right that if ever there was a time, given now what's already happening on the other side of things as it relates to international affairs and how it's going to impact Canada and cause somebody in Ottawa to say we're in a very serious situation here, we've got to stop something on the border in BC or something in Manitoba or something. We got to take some action here because we're afraid this is going to happen. And all of a sudden, other powers are invoked, which completely violate the Constitution.
Yeah. Yeah. Exactly. So I guess what would you recommend? How do we take this decision and make it so that the people across the country pay attention to it, and that people who, in my view, acted politically rather than legally, are held accountable?
Well, I think it will. You can still get carried, at least by the Epic Times, which thankfully are still around, and I don't know who else can. We need to mobilize other people to start writing and get themselves heard. But that's what needs to be done. Now, you can try to activate. I've said to people, if they're part of one of the political parties, well, they should get involved in their constituency organization and the regional part of their party and try to bring proposals. Like, for example, the Conservatives now got a convention coming up. And I know it's all about whether the leader is going to still be the leader or not, which no doubt he will be, because he's got everything organized in his favor. And but at the same time, a lot of people, if they're really concerned about our country, not just our party, but our party through our country through their party, then they should bring proposals forward from their district associations, resolutions whereby they activate this whole business of making some accountability as relates to the decisions that just came down.
Yeah. Now, as you look at it, you were right there at the very beginning when the charter was being discussed and debated in the political realm. And now you've lived by God's grace to be able to see this experience, to see the charter under so much stress through the Emergencies Act invocation. What's your thoughts and with respect to the charter? Did it do what it was supposed to do? And what are your thoughts if this ultimately gets appealed to the Supreme Court of Canada?
All right. Well, let me take the first one, the last one first, the Supreme Court of Canada. Given how this decision is worded and so on, like when we began the show here. This is a pretty strong statement by three very learned judges of the Federal Court of Appeal of Canada. I mean, to me, the government reading that decision and the Department of Justice, I suspect that the Department of Justice, at least privately, as privately as they can make it, will recommend to the government and to the cabinet not to proceed with trying to appeal this decision. Whether in fact there are other parties at play which push this thing in the other direction, I don't know, but that could be. But I can't see anybody out of the Department of Justice reading this thing either bit dispassionately to be able to make any kind of a case before the Supreme Court of Canada. Quite likely, I don't suppose that the Supreme Court of Canada would hear it. They don't have to hear the appeal, do they?
No, they don't have to. And
they can say we're letting it stand as is.
Yeah, you know what? That's a good question.
Or does an appeal
they could just say let it be as it is. In fact, one of the arguments or one of the thoughts I had was that given the fact that the Chief Justice was so outspoken against the truckers and actually encouraged government's use of power, it strikes me that rather than him being forced to recuse himself, which I think he should do, if it were to be accepted and to be heard by the Supreme Court, that they would just simply say, hey, you know what? We're not going to deal with the appeal. That's kind of how I'm thinking they may be dealt with.
Yeah, and hopefully better. It's now clear. I mean, one of the reasons why what really bothers me about the courts and why these three people are so important is, when the lawyers were arguing my case before the federal court, they actually, this is why I thought that the moot argument would not be used. They actually interrogated under oath people from the Department of Health and the Department of Transportation, whereby they stated that they did not have any data and information to buttress scientifically the reasons why they brought in the travel ban. And I thought that once that happened, I remember because my lawyers called me right after that happened, because I didn't hear it right away.
Right.
I thought for sure we would then see this thing get a more favorable treatment, at least it being completely argued in court.
Right.
And not the mootness thing applied to it. And so that's what really worries me about the situation. There are so many instances, of individual Supreme Courts in the provinces who, like the person in Manitoba, who said, I believe what the government data wouldn't look at what Peter McCullough or Brian Bridle or any of the other experts who had no axe to grind except to get the science out there, which in my view represented an incompetence on the behalf of the judge, because the judge had an obligation. His terms of reference for his job was to examine all the information that comes before him or her. And here was this judge more or less saying that I'm not even bothering about this other evidence that's there. I just believe what the government said, which seems to me so illegal. So
it's taking judicial notice, and that's the problem.
I just don't understand that. So so when I look at all of this, and then I think of how the courts continue to ignore the supremacy of God, rule of law provision, which introduces the charter itself. This is not good news, and therefore all the more reason why on this particular decision, dealing with this particular item of the Emergencies Act, is so important to celebrate advance and to see accountability and transparency being forced upon the government of Canada and upon all its systems throughout the country.
Right, right, yeah. Okay, any final comments you'd like to leave with our audience?
Only that this is a very important decision, and as you have highlighted so eloquently, and I support completely. These three people has done a great service to the country, and we only hope that the people of Canada will. I know everybody's sort of tired in one sense, but on the other hand, in democracy, you can't be tired. That's the whole point. That's why most of the world is not a democracy. I have to point out to people all the time that this is a minority system in the world, this business of freedom and liberty and having constitutional structures like we have. This is this. I remember, if I can finish off by saying this, Barry.
Yep.
I was down in Peru, Carol and myself, and we went up to Cusco. And then we went up to Machu Picchu before all the restrictions were placed on Machu Picchu. So we're able to walk around the place. But on going from Cusco up to where you get off the train, we were aboard this train. And I sat next to several students, university students from Santiago, Chile. And they were on their way up to Machu Picchu too. And we got to talking. I got to talking about and I was quite familiar with Chile, and I was going there on that trip as well.
Yeah.
But we got into a great discussion about democracy and so on. And they made the point, and it was so wonderful to hear these students who were democratically minded, who were fighting for all the things that they now have in Chile, which came under a bit of stress in the last 4 or 5 years, but. Like they said on that train to me, we will never go back.
Wow.
We will never go back, sir. We want to tell you, we will never go back. There's enough of us now who know what democracy, and by the way, what an auditor general means, what it means to hold the government accountable, even the democratic government accountable. Once you have what you call a democratic government, doesn't mean you stop, because we know what power does to people, even when they're so-called freedom lovers, when they get a bit of power. I saw it firsthand myself many times, even amongst my ministers in a small province like Newfoundland. How power can suddenly, it's unbelievable. But these kids said to me,
they're not going back.
And guess what? This last election proved that. In Chile, just happened.
Wow.
Proved that.
Okay.
They're not going back, and they had tasted enough and fought hard enough that they knew that their children and their families and so on, and even amongst the indigenous people of Chile this last time, they all voted for the Conservative Party that got in power, because they saw what was happening on the other side, which they were a part of. That power again started to corrupt these more socialistic type people. And even the native people, the indigenous people, saw that this wasn't going to turn out very well, and they voted in their various regions and communities to sustain democracy.
Right on. Excellent. Well, I have to leave it there, but I want to thank you so very much. Again, I very much appreciate all that you do, all that you write. And people are able to go, as I understand it, to your
they can go to my blog, peckford42.wordpress.com, and I'm writing there every day.
Excellent. And many times throughout the day, which I very appreciate. So again, thank you so very much, and all the very best.
Thank you very much for having me, and hopefully some people who hear and watch this will become motivated to get up and fight the cause.
Okay, excellent. Thank you. All the best. You take care. Yep, bye now. The fight for freedom consists not only in the legal battles in court, but also in the battle of ideas at the universities and in the media. It takes time,
effort, and money to keep on top of the debates for freedom. Your donation allows us to keep fighting for all Canadians. Firstfreedoms.ca.